Good afternoon, and thank you for joining me, Andrew Robinson, today to talk about employment compliance. I hope you can all hear me and that you're all able to see the screen. If not, just drop us a line and we'll be able to rectify that for you. Employment compliance is quite a wide topic. Individual elements of employment law can be extremely complex. Things like 2P will have that's a transfer of undertaking protection of employment regs, will have some very strict rules on how they apply. But what we're going to do this afternoon is just have a look over compliance in general, mainly with a view to looking at recruitment and what we need to be doing there to make sure that we're employment compliant, and then just having a look at some of the more recent issues that have arisen in relation to employment law compliance. So in general, compliance, especially where we're looking at new employees but also existing employees, there are certain things we need to be aware of. One is that we need to provide what's known as a written statement of terms within 2 months of an employee commencing employment. A written statement of terms is largely an employment contract. It lists the fundamental things that the employee should be made aware of, such as the time, their start and finish times, their pay, their holiday entitlement, etc. If we don't give them a written statement of terms within 2 months, then they can bring a claim at the employment tribunal for between 2 and 4 weeks' pay. It doesn't need to be brought as part of a wider claim, but it's something that you need to be aware of, and it is one of the few statutory minimum requirements, so just make sure that you have complied with that. Another thing you need to be aware of is that no employee in the UK should work more than 48 hours a week unless they've signed an opt-out agreement. So if you do have employees working over 48 hours a week, you need to make sure that they sign an opt-out agreement from the working time regulations to permit them to work over 48 hours a week. Other things you need to be aware of are, of course, the national minimum wage. So you need to make sure that we are always paying the national minimum wage, and that can be one which you can get caught out on, especially where you've got a situation where employees are on low salaries and then they end up working over and above their normal working hours. If on average they are receiving less than the national minimum wage, then we've got a problem, and so it's one that you need to keep in mind. Another one is notice pay. So employees are entitled to 1 week's notice pay after their first month in employment, and then they're entitled to 1 week for every year that they've worked, up to a maximum of 12 weeks. And there are certain other minimum compliance things that you need to be aware of, such as the right of employees to receive statutory sick pay, maternity pay, time off for antenatal appointments, paternity pay, and other similar things. Type of policies that you should look at making sure you've got in place at all times are policies on discipline, grievance, absence, and also an equal opportunities policy. Also, whistleblowing policy is essential, so outlining what an employee should do if they want to blow the whistle on what they view as an unlawful or otherwise irregular practice. So they should all be documented, all those policies should be available, and you should also be aware of your duties in terms of health and safety and making sure that employees are protected at work and that you look after the welfare of the employees. Health and safety is its own topic and beyond the scope of this webinar, but one that you need to bear in mind. So discrimination is a day one right and runs throughout employment compliance, so you must always be aware of and consider whether or not you may or could be discriminating against somebody. And that's not just direct discrimination, it includes indirect discrimination, such as having a practice, criteria or provision in place which, when applied, could indirectly discriminate somebody against somebody, and that is often in relation to sex discrimination. So if you have a rule to say that employees must be at work by 9 AM and there's no flexibility on that, it might be that that indirectly impacts more on female employees who are still seen as the primary child carers. Discrimination is only where there is a protected characteristic. So we're talking about we're talking about race, colour, nationality, ethnic origin, sex, sexual orientation, gender reassignment, disability, discrimination based on religious belief or membership of a trade union, or pregnancy, maternity discrimination, or the other ones listed there on your screen. So it's limited to what is a protected characteristic, but where they exist, you need to make sure that everything you do is compliant and doesn't discriminate against anyone with one of those protected characteristics. So then, looking at recruitment, what you need to first do is make sure that your recruitment process is free from discrimination on grounds of disability, sex, race, age, etc. And the classic examples there would be to have a job advert which says we are looking for a waiter rather than waiting staff, or we are looking for a young apprentice rather than just apprentice, because of course apprentices can be of any age, or an advert to say we're looking for somebody to join our all-female team or something similar, which then could lead to a claim right from the outset before the person has even applied for the job. They could go on and say, could bring a tribunal claim to say this job advert is clearly discriminatory, and therefore if I applied for the job I wouldn't get it, or they can apply for the job, not get it, and then blame it on discrimination. So you need to keep a list of who's applied. So in terms of your equal opportunities policy, monitor what employees have applied in terms of ethnic background, disability, sex, age, etc. And that's always useful to defend any claims which could come about. And then when you offer the job, it's always worth making sure that you offer employment to somebody subject to satisfactory references. So what we're saying there is that an employee is being offered the position subject to receipt of a satisfactory reference or two satisfactory references. And that allows us, if those references come back as unsatisfactory, to withdraw the job offer without any risks of arguments that the offer's already been made, or that they were entitled to notice pay, or whatever else. Again, it's always a good idea to do pre-employment medical questionnaires. That will allow you to identify any potential medical issues with a prospective employee, and identify whether or not they may in fact suffer from a disability, and if so, take appropriate steps to make reasonable adjustments for that employee. If they're going to be working with children or vulnerable adults, or if they're in a position where previous criminal convictions could be an issue, then again, making the employment subject to a DBS check, used to be known as a CRB check, is always a good idea. So that if in a month or 2 months' time you get back a DBS check which is unsuccessful, or doesn't show or highlights something which is of a concern to the company, you can look to terminate without too many issues. One to always check, which many employers miss out on, is whether or not there are any restricted covenants within the contract of employment, and those restricted covenants are in relation to the employee's previous employment. So it may be you're recruiting a member of sales staff, and they had a sales position in their previous role, and they've got a covenant within their contract to say they shall not, for a period of 6 months, work in a similar industry, in sales, etc. If you don't check that and you hire that employee, then you could be in a position where not only does the employee face a claim by a previous employer, but you also face a claim for inducing that employee to breach those restricted covenants, and so you could find yourself defending a claim both on behalf of the employee and on behalf of yourself. If that employee is already in work, locked in, perhaps they've got a 2-3 month notice period, contractual notice period, which you've given them, not easy to get rid of them unless you make it absolutely crystal clear that any employment is subject to them not having any working restrictions or restricted covenants within their contract. So it's always worth having a think about checking out, and if they do have a restriction, taking advice on whether or not it's likely to be binding. So is it for a legitimate business purpose and reasonable in scope? But whether or not you're likely to succeed, you have to bear in mind the cost associated with defending such an action and decide if it's worth the risk. Another big one to think about in terms of employment compliance on recruitment is making sure that you don't have any illegal workers. So what we're talking about here are people without the right to work within the UK. The current fine is up to £20,000 for each illegal worker. So if you were to receive a visit from the enforcement agency and they were to find out that you had illegal workers, then you could be looking at a fine of up to £20,000 for each one. How do you protect yourself against that? Well, there is a statutory defence, and what that involves is making sure that you've taken reasonable steps to check if that worker is legally allowed to work within the UK. So we're talking about things like making sure that you see original documentation, you check to make sure that documentation is valid, you take copies of that document, those documents, and you record the date you did it. Sometimes there's questions over whether or not visas and things are valid. There is a line you can call to check to see whether or not the current immigration status of an employee, but the onus is very much on the employer to do so. So it's a big one to check and make sure that you don't have anyone illegal working within the organisation, because the fines and enforcement of that area of employment law is only going to become more stricter as we move forward. Another interesting one is part-time and fixed-term employees. So you employ someone part-time or on a fixed-term contract. You must make sure that they are not treated any less favourably than full-time permanent employees. So the example we've got there is gym membership. If you provide your full-time employees with gym membership, then there's a good argument that your part-time employees or fixed-term employees should receive the same. Pay rates should also be the same, as should holiday and career development opportunities. Clearly things like pay would be prorated, but it shouldn't be less just because you are a part-time employee. Overtime and working time are two major topics which have been in the press recently, especially over the last sort of 12 months. Overtime and holiday pay, and commission and holiday pay. Since a ruling by the ECJ, it's clear now that if people receive regular overtime pay or regular commission, so that's overtime which they would expect to receive on an average week or on an average month, and commission which they again would expect to receive on an average week or average month, then that should be reflected in holiday pay. So the tradition is to pay people for overtime if they work it, but whilst they're on holiday, just for them to receive basic salaries. That now could easily lead to a claim for unlawful deduction from earnings. So, and what that means is that people can go back. Well, they can go back a maximum of 2 years. Often they'll be restricted from going back more than sort of 3 or 6 months, but in theory they can go back up to 2 years to claim for unpaid holiday pay on the basis that they didn't receive their full entitlement. That is holiday pay including the average overtime they would have worked or the average commission. Working time, recent decision on that, which says that working time includes the time travelling from the employee's home to a place of work where they do not have a fixed permanent place of work. So an example, so that is for home workers who were largely on the road, who maybe have different places of work to go to on a daily or weekly basis. What the decision means is that from the moment they get in the car and set off, well, that is treated as working time. It doesn't affect national minimum wage as yet, because we're only talking about working time in terms of not working over 48 hours a week, and the right to receive 20-minute rest break after 6 hours and things like that. But employers do need to be aware of the fact that the clock starts ticking from the moment a home worker gets in the car, and therefore they need to make appropriate provisions for that, not least making sure that they've signed out of the 48-hour opt-out. And between employees and genuine self-employed persons are workers. And workers have certain rights. They don't have as many rights as employees, but they do have certain rights. They have the right to receive holiday pay. They have the right to be also enrolled in a pension. So if there is once a company is given its staging date, they must provide a workplace pension for all workers. So that's both employees and workers. And they also workers are also entitled to not working more than 48 hours a week, and to rest breaks between shifts and during shifts, and they're entitled to receive national minimum wage. So the current national minimum wage for over 21 is £6.70 an hour. And we then look at best practice. So in terms of minimum compliance for employment law, there isn't in general a long list of you must do X, Y, and Z. Clearly the Section 1 Statement of Terms is an example of an absolute, but when it comes to what the tribunal is looking for, it is often looking for best practice or sort of minimum best practice, and that includes ideally having a detailed bespoke handbook full of policies and procedures which ensure that your company manages employee issues in a fair and consistent way. And that's policies and procedures and everything from things like shared parental leave through to disciplinary policies on flexible working and that sort of thing. And also to have written statement of terms which go further than providing the minimum, but have detailed provisions within them, such as rights to make deductions from earnings, mobility clauses, rights to move the work location and that sort of thing. And also to make sure that policies are followed consistently and reasonably. And if you do that, well, then hopefully you'll stay out of the tribunal, or at least have a good defence if you end up in the tribunal. So employment law compliance largely comes down to common sense and basic justice in many respects. It's making sure that you apply things fairly and consistently, and that you've got the basics in place in terms of policies and procedures. We'd always advise that you go much further and you operate to best practice by having detailed trained staff, line managers, and all the rest of it. But compliance, as a minimum, is largely dealt with in the points that we've just gone through. As I say, individual areas of employment law will have their own very specific requirements, and we'd always advise you to take advice on those before undertaking any disciplinary procedures or redundancy procedures, things like that. Well, thank you for listening, and if you do have any questions at all, my email address and telephone number are on the screen, and I'm more than happy to take calls or answer emails on anything we've discussed there, or anything else that you would like to answer on in terms of employment law compliance, or anything else.